Okay guys, I know we have a small house right now, but I imagine more people will filter in. I'd like to introduce Paul Bergman. He's a professor at UCLA School of Law with a current teaching assignment in evidence. He received his JD from Berkeley Bolt Hall, and he clerked in the Ninth Circuit Court of Appeals, and before entering law teaching, was an associate at Mitchell, Silverberg, and Duff in Los Angeles. He's given numerous film clip-based presentations to groups of lawyers and judges all over the country and has appeared on numerous radio and TV shows, including The Today Show. He's also written more than 50 law review articles and book chapters on a wide range of subjects, including the images of law, lawyers, and justice in popular culture, and he's here to talk to us about evidence. And also, in case anybody is interested, this is not the purpose of this, but he did bring a couple copies of his book, Real Justice, if anybody wants to ask him after the presentation for purchase. So, without further ado, Professor Bergman.
Jessica. Hello, everybody. Glad to see you here. I told Jessica that back in the late 70s, our UCLA clinical program actually did a lot of dependency court cases. And then one of my colleagues, Paul Boland, I don't know if any of you knew Paul, but when he took the bench and he was assigned to dependency court, and he changed the procedures in a way that made it less likely that we'd be able to get students into court in a period of time that we needed. So he went from supervising students in lots of dependency cases to make it impossible for those he left behind to supervise students in dependency cases. All in the name of fair procedures. His priorities were totally out of whack, I think. We have a limited time. Jessica asked me to focus on evidence, impeachment, and since I do a lot of presentations using film clips, I thought we'd start out by showing a few which raise the kinds of issues we're going to talk about, and then the handout I tried to put down some of the basic California rules about impeachment, rules and procedures about impeachment, and hearsay. Probably many of them familiar to you, but I thought I'd run through some of those. And then there's some little hypotheticals at the end of the handout, and so maybe we'll finish up with those. So let's start out. I thought you see here Betty White, who seems not to have aged at all in the last 60 years or so. And I understand she was honored at the Emmys last night. So this is a clip from a TV show that many of you may have seen, The Practice. It was the #1 show for a long time in its time slot, and then it morphed into Boston Legal before it went off the air. So I'm not sure which of its, this is sort of in the transition phase. But anyway, Betty White has come to testify as a witness to a murder. And she has, her testimony is going to be inconsistent with what she has previously told the defense counsel. So let's see what happens when Betty White testifies.
He would come to her house at least 3 times a week. He'd park on the corner of Milton and Toby, and then he'd walk a block.
3 times a week?
Yes, to have lascivious sex with her.
Miss Piper, on the day Brenda Wilbur was murdered.
He was there.
When?
Well, he came in the afternoon, and then I saw him return that night, before 10.
Objection.
On what grounds? From my interview with the witness, I believe she's misspoken.
No, I haven't. Could I be allowed to finish?
Sure, Mr. Shore.
You saw him return at 10 p.m.?
Yes.
On the night Brenda Wilbur was murdered?
Yes.
And when did he leave?
Just after 10:30. And he was running like there was something terribly wrong.
Now, Miss Piper, when the police first questioned you, you said nothing about the defendant being there that night.
Because Victoria Stewart, Paul's mother, paid me $600,000 not to.
Her dead.
The mother of the defendant paid you $600,000.
And I'm so ashamed to say I took it. I think that's why Mr. Shore was expecting me to lie just now. But my conscience simply got the better of me. That's why I came to you. I'm not the noblest of people. I'm obviously not above extortion or even lying. But I just couldn't lie to help somebody get away with murder. No, I can't do that.
That's a great scene. So I show that to, when I show this clip to students, I ask them to analyze. There's that little bit there where the defense lawyer says to his client, we're dead, because the defendant's mother bribed the eyewitness to change, to lie about seeing the defendant in the house where the murder took place at the time and of the murder. So, are they dead? Is there any foundation missing here, without which the evidence really isn't relevant? And so you're not students, so I'm not going to call on anybody or point at anybody. But what I want them to recognize is that without tying the bribe to the defendant, that the evidence is irrelevant. Paul Stewart's mother may have believed he was guilty. The bribe is evidence of her opinion that he's guilty. But unless there's evidence tying the defendant to the bribe, either he acquiesces in it in some way, or perhaps even if he knows it's taken place and he doesn't do anything about it, but without linking that to the defendant, the evidence of the bribe is irrelevant. So that's a nice little evidentiary point, not hearsay or impeachment perhaps, but I thought it's a nice way to start off our little exercise here. And really what I like to show clips, or I got started showing clips, because I wanted students to, when they see courtroom scenes, especially in movies and TV shows, I want them thinking about it. And what would I do? Is that proper procedure or not? If not, what would I do about it? Is that ruling accurate? To me, it's a way of giving shelf life to a course that wouldn't otherwise happen. And I'm delighted when students come back and tell me, if they've learned something about evidence over the course of the semester, that's great. But if they come back and tell me that they saw this old movie and you wouldn't believe what they saw happening in the courtroom, then I'm really proud of my teaching. Okay. So the next clip is going to be more on point, perhaps. It's from a deservedly little-known movie called The Good Mother with Diane Keaton, and it's a... two doors. Right. It's a custody battle. Diane Keaton has custody of an 8-year-old girl. Her daughter and her husband, ex-husband, is seeking a change of custody, and he's going to testify to some statements made to him by his daughter during a visitation, and it has to do with what happens when the daughter is at the mother's home, in which her live-in boyfriend, Liam Neeson, is living. I think this was Liam Neeson's first movie, by the way. I think he's in this clip. So here's The Good Mother.
He was very curious about my body. Well, about our bodies, my wife's and mine, in a way that seemed new and inappropriate to me. We'd always been very careful not to distress her or scare her by having her see us naked.
When you say we, you mean?
Well, in both marriages. It seemed to me that Molly was, had changed around this issue. That there was something preoccupying or frightening her. And then one time she just asked me straight up. I was shaving. if she could see me. And I said, no, that's my business. And she said, well, Leo lets me see his penis. He lets me touch it.
Objection, that's hearsay.
Sustained. You know better, counsel.
Thank you, Mr. Dunn.
Okay, did counsel know better? Is that hearsay? The statement that Leo lets me see his penis. The question is there a non-hearsay use for it? You know, I think with a little analysis and thought, the father's attorney there, had he thought about it more carefully, should have said, Your Honor, we're not offering it for its truth, but whether or not what the daughter said is accurate, it shows as inordinate interest in sexual matters, in body parts, and just the fact that the statement was made is some evidence that the mother's home is not a suitable place to be raising an 8-year-old girl. So I think there is a legitimate non-hearsay use for which that could have been offered. But again, the movie doesn't illustrate that. It just illustrates said out of court must be hearsay. So that's the way I would analyze that clip. I'm going to show 4 of these clips, because I know our time is limited. The next clip is from, again, the practice. This time it was definitely still in its practice phase. This is one of those clips that you could teach perhaps half of the evidence course and maybe half of law school in general. There's so much going on in this clip. What's happened here, the testimony is unfolding in a hospital room. The alleged victim claims that his wife, he got out of the car to open the garage door. They did have garage door openers in the era when this was filmed, but apparently they didn't have one. So he gets out of the car to open the garage door, and she decides that this is a perfect opportunity to try to bump him off. So she supposedly floors the car, runs into him, and he ends up with severe injuries. He's in the hospital, and she's charged with attempted murder. So the hearing the trial is going on here. We have a judge, we have the prosecutor, and we have Eleanor Frutt, I think her name was, cross-examining the victim. Can you see, by the way?
You said you were suspicious when your wife asked you to go shopping. Had you never shopped with her before?
Oh, a few times, but certainly not enough.
So you had then. When you said never, that was a mistake.
Well, I can overstate. It was just not the usual thing for me to shop.
And when you got home, you got out of the car to open up the garage door.
Yes.
And then you moved in front of the car?
Yes.
And how many feet in front of the car were you standing?
3 feet, maybe.
3 feet. And when you opened up the garage door, the car suddenly came at you?
Yes.
Fast or slow?
It just sprang at me. It lurched forward and ran me over.
How many seconds did it take to run you over?
Second, maybe less. It just exploded toward me. She floored it.
She floored it. Could you see the floorboard of the car?
Of course not, but the way that car sprang forward, she had to have just gunned it.
Knocked you down in less than a second?
Yes.
Half a second?
Maybe.
And in that half second, you saw the car come at you?
Yes.
And in the remainder of that half second, when you weren't looking at the car, you saw your wife's face?
I saw it good.
For less than a half a second.
I didn't time it, but I saw it good.
You said you wanted to divorce her, right?
Yes.
Didn't have any feelings for her anymore besides hate. Wasn't that your testimony?
Pretty much.
And since you've developed this heart condition, you've been gifting away as much of your estate as possible. You've even told friends that, right, Mr. Morgan?
Keep it away from Uncle Sam.
And your wife, didn't you tell some friends you don't want her to get it?
So?
In fact, the one thing you hated about the prospect of divorce was that she'd get half, right?
Which she didn't deserve.
But if you could get her convicted of attempted murder, that would surely disqualify her, wouldn't it?
This isn't something I hatched up.
It's exactly that. Objection sustained. When the police and the paramedics first arrived, you said nothing about her trying to kill you, did you, Mr. Morgan?
I first didn't believe it.
Didn't tell the police anything about her face then, did you?
I was half dead.
And then it came to you like $1 million brainstorm? Objection sustained. This is a way of getting even, isn't it, Mr. Morgan? Get her convicted of attempted murder, argumentative counsel, disqualifying her from everything.
Yes, I ran myself over.
This was an accident. You came up with the idea about the expression on her face, which you thought of later, based on a glimpse of less than half a second.
She's badgering the witness.
No, I'm cross-examining. How is it that you didn't know she tried to kill you right after the accident, but that you came to know it later, sir? What happened since the accident?
I figured it out.
Well, what happened since the accident that allowed you to figure it
I
out?
put two and two together.
So it wasn't the expression on her face.
Yes, it was.
Did hate color your figuring, sir? Did money color it? Mr. Morgan, this could be your last chance. Did she try to kill you? If yes,
To exclude Mr. Morgan's testimony on the grounds their cross was cut short, a decision which would border on judicial misconduct, we could nevertheless still introduce Mr. Morgan's statement that his wife Louise tried to kill him.
why?
How? As Mr. Morgan was suffering his fatal coronary, I asked him that question. He answered yes, an answer which would qualify as a dying declaration which needs not be examination in order to be admissible.
Is that why you did that? Asked him to squeeze the doctor's hand, and you're calling me despicable?
Well, that's a, you know, it's a great, the timing of that scene, isn't it wonderful? It makes a cross-examination look and sound like Fast and the Furious or something like that. What are the issues here? I mean, it's you have basically it's offered as a dying declaration. So would it be admissible as such? You actually get to slightly different answers under the federal rules of evidence as a California evidence code. I put the dying declaration hearsay exception in the materials at section 1242, I believe, yeah, of the evidence code. Probably not a section which you work with very often. I don't know how often dying declarations are actually offered, but it's actually one of the oldest of the hearsay exceptions. And if you remember the Crawford case, you know, the whole which reformatted the analysis of the Confrontation Clause applicability to hearsay, one of the things Scalia said in that opinion is that, well, the dying declarations are not, you know, would never be considered testimonial, or at least were not considered testimonial by common law. So, what would be the issues here? First of all, you know, for hearsay, the very definition of hearsay is an out-of-court statement, right? So, is the statement made out of court? That's not an issue that arises very often, right? But here, who knows, right? He's coding, you know, are we in recess? When the doctor goes, the judge hasn't declared a recess. Is it still made as part of the courtroom proceedings? So that would be a first level issue you'd have to think about. Again, not one that is likely to arise. Secondly, a second issue there is it's a nice review of assertive conduct. He doesn't say anything, but you know, the issue there, you know, he's asked, if you think your wife was trying to kill you, squeeze the doctor's hand. So the squeeze of the hand is the equivalent of an assertion, my wife was trying to kill me. Then you've got the opinion and lack of personal knowledge issue. You know, hearsay is admissible. There's always the hearsay declarant has to have personal knowledge. Well, what he's testifying to by squeezing the hand, in essence, is his wife's intent, state of mind. Does he have personal knowledge of that? Which is basically what the the whole cross-examination is about. If he doesn't have personal knowledge for purposes of the trial, he doesn't have it just because it's offered as a dying declaration. The assertion has to be made at a time when the person believes that death is imminent. Probably, right? He's not looking too good there. At the time he squeezes the doctor's hand, he's had heart problems. So probably we could say that the declarant believes that death is imminent at the time the statement is made. The declarant, and this is a little different from the federal rule of evidence, for the federal rule of evidence, the dying declaration exception does not require that you die, right? You have to be unavailable for trial, but as long as you thought you were going to die and you made a statement that concerns the circumstances of what you thought was going to be your death, if you don't actually die, it can still be a dying declaration, but not in California. You have to actually die. Now that seems obvious, but I have seen a couple of treatises who miss that point. And somehow, the way the statute is phrased, maybe it encourages that, I don't know, but it does say, respecting the cause, what's the exact language? Respecting the cause and circumstances of his death. So you have to die in California for a dying declaration to be admissible. So when you have the opportunity, advise your clients or people you care for to make dying declarations under the federal rules of evidence, because they don't actually have to die for it to be admissible. Again, not likely to come up very often. Well, there's that issue. Does the dying declaration concern the cause and circumstances of his death? Okay, so now we're back to good old but-for causation. If he died from being hit by the car, then it does. But what if he died from a heart attack, a pre-existing heart problem that had nothing to do with the fact that he was hit by the car? Now, it doesn't concern the cause and circumstances of his death, so it's not admissible as a dying declaration, nor would it be admissible as a dying declaration if the actual cause of death is cross-examination. A terrible way to go, death by cross-examination. But again, it would not be, so getting over all that, let's assume that we get over all those hurdles. Would it be admissible? In California, yes, because California does not have a limited admissibility on what kinds of cases dying declarations are admissible, and obviously they have to be relevant and the other foundational issues we've talked about. The federal rules do. Says dying declarations are admissible only in civil and homicide cases. This is not a homicide case, right? It's a case involving, the charge is attempted murder. So if this were a federal court case, they'd have to dismiss it, recharge it as a homicide, and now all those issues would reappear. So this is a pretty complex little piece of examination, but kind of a fun one. So that's the practice. And the last one is show not nearly as dramatic, nor is it a movie. This is a clip from an actual wrongful death trial that one of my colleagues filmed up at McGeorge Law School, filmed a trial that they had conducted in the law school so that students could watch it, and it was video recorded, and this is a short clip from that actual trial. And what happens here is the witness is a woman who was driving, a passenger in a car being driven by her husband in the Sacramento area, and it's a very foggy morning apparently, and the car in which she's a passenger is passed by a car which allegedly was speeding, going too fast especially for the conditions of the fog. Some 10 minutes later or so, this car is involved in an accident which results in the death of the driver who was driving the car that passed the vehicle in which our witness was a passenger. And so the issue is whether or not the real cause of the injury was not someone else's driving, but the fact that the woman was racing, driving way too fast, and basically got in an accident due to her own carelessness. The issue is going to be a statement. The woman, the passenger, is asked about a statement which she makes to her husband after this car passes her. So let's see a little bit of testimony offered here by the defense counsel.
While driving in the fog, did you become aware of a vehicle anywhere on the roadway which later turned out to be involved in an accident?
Yes.
Okay. I'm specifically talking about a passenger vehicle.
Yes.
Now, where did you first see the passenger vehicle?
When it was passing us.
Okay. And where was that in relationship to where the accident happened, either in distance or time?
It was before we got on the causeway.
And the driver of the vehicle, did you see whether it was a man or woman?
Yes, it was a woman.
Okay. And it's been almost 2 years, but as you sit here today, do you have a recollection of seeing that lady?
Yes, very clearly. She was driving along and she was smoking a cigarette.
In this mental picture that you have of her, was she wearing glasses?
No.
Do you wear glasses?
No.
Does your husband wear glasses?
No.
Do you notice whether or not people wear glasses?
Usually, yes.
Now, what was it about this woman at Benjamin as she passed you that called your attention to her?
Well, number one, it was the only vehicle that passed us after we got in the fog. And the fact that she was going much faster than we were. At that point, we had already started slowing down because the fog was getting dense.
Do you have any estimate as to how much faster she was traveling than your vehicle?
No, I can't honestly say.
Okay. When you noticed that lady, what was your state of mind with regard to her actions when you saw her?
Well, I was surprised that she was driving so fast. It was rather frightening.
Did you make any statement as to your state of mind to your husband at that point?
Yes, I think I said something like, boy, if she doesn't slow down, it's an accident going someplace to happen.
Okay, so the hearsay issue here is the admissibility of her out-of-court statement to her husband. If she doesn't slow down, she's an accident waiting to happen. So the issues to think about here, one is, first of all, hearsay in the form of speculation is not admissible. It doesn't, speculative statements don't become admissible simply because they're in the form offered as hearsay. But probably the way to analyze that, you analyze hearsay issues by looking at the intent of the speaker. What is she really meaning to say? And by saying she's an accident waiting to happen, we could probably reasonably understand that as a statement that she's driving way too fast for the conditions. Probably a permissible opinion based on everyday experience, not a speculative prediction about what's going to happen. Okay, so we get over that issue perhaps. Then the issue is, what could this be offered as? A spontaneous exclamation, right? California has a hearsay exception for statements made spontaneously. Now, the common law really required that the word spontaneous, which is still in the California Evidence Code hearsay exception, is more or less disregarded. I mean, in common law, if a hearsay declarant made a statement which we would recognize as made under the stress of excitement, but it was preceded by a question like, what happened? It wasn't spontaneous. So you could imagine, a lawyer back in the common law days holding everybody back. Don't ask any questions. Let's see what this wounded or whatever person comes up with on their own. Because if you ask anything, you're going to ruin my case, perhaps. Okay, so the word spontaneous is in there, more or less disregarded, although obviously if some conversation precedes the making of the hearsay, that could be taken into account as to whether or not the person was under the stress of excitement. One issue is she doesn't sound very excited there. The plaintiff's lawyer, defense lawyer does go to the trouble of asking her, what was your state of mind? And she says, I was surprised. That's a little bit of a foundation, perhaps, for an excited utterance. Much better if she had told her husband, oh my God, if she doesn't slow down. Oh my God is the hallmark of the excited utterance. So, couldn't you have said, oh my God, first? But the other reason I want, she doesn't sound very excited. So I wanted to, stress that because if you studied evidence, you probably studied the federal rules of evidence, and if under the federal rules, it doesn't matter because the federal rules have an exception called the present sense impression exception, the hearsay rule, which says that you don't have to be excited. If you make an assertion about an event at the time of the event or immediately after, it's admissible as a hearsay exception, right? So clearly this is admissible under the federal rules. California has not enacted the present sense impression exception to the hearsay rule. So it's a little more questionable under the foundation. I would say work a little harder to make it pretty clear that this woman was, spoke in a state of stress and excitement and anxiety about the speed of the car that passed her. Okay, so I'll leave it at those clips, and let's get on. Let's look at some of the exceptions here. The first section, I more or less went in order. I'm not going to talk about all of these, but 770 is just incorporates a little procedural issue that I just probably maybe you're all aware of it, and forgive me if you are, but I'm just trying to cover things that seem to me important with impeachment and hearsay. 770, 1235, which is later in the little handout there, is the hearsay exception for prior inconsistent statements. And as you probably know, in California, different from the federal rules, any prior inconsistent statement which is admitted into evidence is admissible for its truth. The federal rules say admissible for its truth only if they're made under oath. But in California, all prior inconsistent statements that are admitted are admissible for their truth, as well as, of course, to impeach. 770 is a little procedural footnote to that. And it says that if you're the cross-examiner and you want to offer into evidence a prior inconsistent statement of a witness other than by cross-examination, in other words, extrinsic evidence. You want to offer a document that contains the prior inconsistent statement, or you want to call your own witness to testify to the inconsistent statement, but you don't want to cross-examine about it, it has this little procedure here. It says that 770 says you have to cross-examine the witness about it, or you cannot excuse the witness from giving further testimony if you choose to offer extrinsic evidence. Okay? And so that's to make sure that the court, the witness is still under the control of the court to be brought back should the party that called the witness want to offer rebuttal or have the witness explain why they made this prior inconsistent statement if they didn't have a chance to do that while they were on the stand in response to cross-examination. Okay, so that's a kind of a procedural holdover from the old common law days when a impeachment with prior inconsistent statement had to be preceded by a little ritualistic, some foundational questions. You know, why would you want to offer extrinsic evidence? Well, so that you don't get the explanation, right? If you cross-examine and offer a prior inconsistent statement, there's a big risk that the witness might have a reasonable explanation, which vitiates the impact of your cross, so you may choose not to offer the statement when the witness is on the stand and do it yourself. Now that extrinsic evidence option is available only if the evidence, the statement, does not pertain to a collateral matter. Now back a few pages, 3 or 4, I have the collateral evidence rule in the middle of the page there underneath section 790. That is not a rule which has been formalized in the California Evidence Code. So it's kind of a common law rule which basically says, applies to extrinsic evidence. And it says that if evidence is collateral, in other words, not all that important to the issues in the trial, extrinsic evidence is not admissible. So if you want to offer evidence of a prior inconsistent statement made by the witness, and there's a risk that it's collateral, then you have to cross-examine the witness about it. You don't have that option to not excuse the witness and then offer the extrinsic evidence. Okay? So obviously it's a judgment call as to whether or not it's collateral, but if it is, you're foreclosed from offering extrinsic evidence. If you're looking at the collateral evidence rule, since we're talking about it, prior inconsistent statements might or might not be collateral, depending again on how important the matter is to which the statement relates. Contradiction, you know, the witness says there were, you know, it was a blue car, and you want to contradict by offering evidence that it was a red car. Maybe collateral, maybe not, depending on whether the color of the car is important. You can't offer contradictory evidence just to show that the witness is mistaken about some fact that doesn't really relate to the important issues in the case. That's the idea. Bias, never collateral. Evidence of bias, you know, isn't it true you're the defendant's mother? No! You can offer evidence that the witness is the defendant's mother, right? Not collateral. Bias is never collateral. Prior bad acts, collateral. You're not allowed to prove up prior bad acts if they're admissible only for character evidence purposes. Convictions, not collateral. Convictions to impeach, I'm talking about here. Not collateral if they involve moral turpitude. Okay. And testimonial defects, hearing's not so good, the eyesight's not so good, Memory's not so good. I'm describing myself here, for those of you who don't know me. That stuff is never collateral, okay? Because that's generally important if the witness has the sort of mental and physical capacity to be able to remember or do what they said they remember or did, okay? So that's the collateral evidence rule. Again, it only applies to extrinsic evidence. When extrinsic evidence is admissible, it is if it's not collateral. Okay, so let's go back here. Let's see, other statutes that might be important. 1222 on the, I guess, the third page of the handout. I included that one, again, you know, just to, this is the, in the admissions section, and basically it comes up with the admissions offered as a party, by a party when they're made by somebody else, so-called vicarious admissions, where you have to show that someone had speaking authority for the party, and you're offering it against the party. The highlighted area there in B is because in California, the foundational issue is there speaking authority. Were these co-conspirators? Was the person who spoke an employee? Did it concern the scope of employment? All of these are decided under the lower foundational threshold of sufficient to support a finding. Okay, the judge does not have to be convinced that speaking authority exists, that they are co-conspirators, so long as the jurors, if they have a jury trial, which I know you don't have in dependency court, but you know, so long as the jurors could reasonably conclude that the authority exists. In the federal rules, that is what they call a 104A. The judge has to be convinced. So there's the point is simply that there's a lower threshold of admissibility in California for vicarious admissions than under the federal rules. 1240 is what we were just talking about, the excited utterance. 1242 is the dying declaration. The impeachment, character impeachment rules, a couple of the hypotheticals that Jessica sent me as possible to talk about did concern character impeachment, and so I thought I'd put the basic rules, which in California are pretty restrictive. Like the federal rules, character evidence on the issue of credibility is not admissible to support a witness's credibility until after that witness's character for honesty has been attacked. The familiar bad before good rule, same as in California and in the federal rules. 787 says you cannot offer evidence of specific instances of conduct. You can't ask a witness about, let's say, specific instances of lying or untruthfulness or deceit, whatever it is, to attack their credibility. You can only offer, doesn't affirmatively say, but what's left is opinion or reputation evidence. You can offer evidence that an opposing witness should not be believed because they have a reputation for dishonesty or in the opinion of a witness who knows them well, in their opinion, they're not trustworthy. So pretty limited in California in civil cases, which is what this is a summary of. And then 788 is the prior convictions. You can attack credibility with a prior conviction so long as it's a felony, and a felony that involves moral turpitude. Most felonies do, but there are some that have been held not to involve moral turpitude. And then I have this little matrix here, which just kind of gives you the order in which helpful to think about hearsay issues. First is an out-of-court statement being offered, usually not a problem, but is it an assertion, or is it some kind of spontaneous reaction, perhaps? And there's no actual assertion, so it's not hearsay. For what purpose is it offered? If it's for a non-hearsay use, is it relevant? And then the relevance versus the unfair prejudice. If it is offered for its truth, does it satisfy any of the exceptions to the hearsay rule? Again, as probably if you know, the federal rules have recategorized a few traditional exceptions and what California regards as exceptions as exemptions, but that doesn't make any difference. And then finally, if you get past all that, in a criminal case in which the hearsay is offered against the defendant, then you have to analyze its testimonial nature and whether or not it might be barred by the confrontation clause. Okay. All right, I know, so let's go through as many of these hypotheticals as we can. Some of these I contributed, some of these Jessica contributed on your behalf. So father, number one, father testifies that he denies that he's been in contact with the mother. He's been ordered not to be in contact with the mother. On the mother's phone are text messages from the father that have been sent after issuance of the order. How can the text messages be used to impeach the father? Presumably, if you have a permanent restraining order and the father has violated it, then the collateral evidence rule would not bar extrinsic evidence of the text messages. The primary issue I saw in here is, is the authentication. How can you demonstrate that the father actually sent the text messages? Authentication is, can be a tougher issue in in a world of electronic and digital messages. When you read the authentication sections of the federal rules, California Evidence Code, etc., they're all assuming a world in which people are writing letters to each other and signing their names to documents and doing all these things that people used to do until about 10 years ago, and now nobody does those things. You have the umbrella clause there in 1400 that evidence, you can authenticate by offering evidence sufficient to sustain a finding. That's that lower foundational threshold again. You don't have to convince the judge of authenticity. It's sufficient if authenticity could be found to exist. That the writing is what the proponent claims it is. So any way you can do it, and I included in this context, I thought that one of the ways of doing it might arise in 1421, more or less self-authenticating, or so-called authentication by content, that the matters discussed, thank you, in the messages are unlikely to be known by anyone other than the proponent. If they're referring to, you're contacting the mother about issues relating to the child, there's a good chance that that itself would establish, authenticate the father as the sender. Number two, we have a domestic violence case. This is the setting, the scenario for a lot of the Crawford jurisprudence, because as we know often happens, the mother makes a complaint, tells the police that she was abused, and then she changes her mind. and then says that, well, nothing really happened, I lied, I was angry, whatever, I came upon these injuries accidentally, I fell against the door, whatever it is. So the issue is, can the basically prosecutor call her as a witness, and when she denies that any abuse occurred, impeach her with her prior statements? Well, you see a couple pages back, Evidence Code Section 785, the credibility of a witness may be attacked or supported by any party, including the party calling him. Now that would seem to, on the surface, allow this kind of procedure, but the statute is not quite as comprehensive as it suggests. The general rule is that you cannot call a witness to the stand solely for the purpose of impeaching them. Okay, you have to have a good faith belief that the witness is going to support, offer affirmative evidence for your claims, and then if it turns out that the witness kind of unexpectedly, or maybe will not support all of your claims, but testifies inconsistently, then you might be able to impeach with a prior statement. But not as in this case, where the witness is not going to offer evidence, and you're calling her here just for the purpose of getting her prior statements into evidence. Okay, let's see. I know we're running short on time. Let's see what. Let's see. Number 5, 6, and 7. These were basically the facts of the McMartin case, which was one of the original, teachers allegedly abusing young students in various ways. So in 5, a preschool teacher is charged with abuse. The child testifies hesitantly and incompletely. Can a police officer basically offer prior consistent statements in which the child was much more forthcoming? The answer to that is no, because if a witness performs badly on the stand, you can't offer evidence that at some earlier time they testified much better than they were able to on the stand. Okay, as long as there's been no attack based on motive, fabrication, to change your story, and then you can show, well, before that motive arose, they told the same story. There's simply no foundation to offer the consistent statement. If you turn it around in number 6, the child testifies fully, capably, and competently, explicitly to the details. Can the defense attorney call the police officer to testify that in a pretrial interview the child was hesitant and incomplete when describing the abuse? The answer to that is yes. That is now the fact that the child's memory and ability to testify at an earlier time was worse than it is at a later time. That's essentially an inconsistent statement. Most of us don't have the experience of getting better over time with our memory. So that's suggestive of coaching, and so it's a way to attack the credibility of the witness by showing that it was sandpapered. So that's under number 7. I just included the example from the famous Triangle Shirtwaist case, which was a watershed case about 100 years ago in the annals of the American labor movement. And I'll let you read it. It's where an attorney violated the supposed ironclad rule of cross-examination. Don't let the witness retell their story on cross-examination. And here, an attorney, well-known attorney at the time, did exactly that and got some good results from doing it, but I'll leave that to you. To impeach a child witness, number 9, can you offer evidence the child has a tendency to lie? You can attack credibility. That's basically character evidence, but remember, opinion and reputation only, and you'd need an adequate foundation. Say, in my opinion, this child is trustworthy, or the child has a reputation for lying. Mental health issues, that's not character evidence. That someone has serious mental health issues that could affect their perception, probably have to be offered through an expert witness. It might affect their perception, memory, etc. That is not character evidence, so that is okay. The child smokes meth. You can't attack them because they, specific acts which are violating the law. But if you can show that they were either smoking meth at the time or under the influence of meth at the time that events occurred, or that they've been smoking meth for so long that it's now become an impairment of their testimonial capacity, memory ability, then that would be appropriate impeachment. D there cross-examines about fraud-related criminal history. I actually don't know what CLETS is, I'm sorry, but I assume that's some kind of a rap sheet. No, you cannot in California attack credibility based on character with a bunch of bad things they've done. Grandfather, number 10, denies that his testimony is influenced by desire to obtain custody. Evidence that the grandfather told people of his desire to obtain custody, that's a prior inconsistent statement, would not be collateral. So you could cross-examine the grandfather about those other statements if you wanted to, or you could forego cross-examination and call the people to whom he made those statements as witnesses. Number 12, this is one of those, 13, sorry, I guess we're just about out of time here. This is multiple hearsay issue. The students love these. County counsel as a social worker, what did the foster mother tell you about the mother's visits? Or what did the child tell the foster mother, which then the foster mother supposedly must have told the social worker. So you got a string of hearsay here. Are these statements inadmissible under the hearsay rule? Well, I would assume so, if offered for their truth, unless there is some special hearsay exception that operates in juvenile dependency cases for statements made to social workers. Or if the issue is whether the social worker had a reasonable basis for doing what he or she, taking some action that he or she did, then the fact that these statements, this information was offered to the social worker would be admissible as non-hearsay. But if offered as evidence that for the truth of whatever the foster mother told, said to the social worker, or the child said to the foster mother, all of that would be hearsay if offered for their truth. Let's see. So I guess we're out of time, right? I think so. I put little hints for some of these hypotheticals so that you could check on them yourself. And so I hope this was helpful to you. I feel like I've been in a 100-yard or 100-meter dash, I guess, or something, kind of racehorse. So I thank you for coming. I appreciate you being here. I do have these two books. They cost me $10 each. If any of you wants one for $10,